That is also the dictate under Article 3 of the Constitution, where every person has an obligation to respect, uphold, and defend the Constitution. We choose to abide by that calling. As such, public interest demands that the office of the Deputy President should not remain vacant. Whether the constitutional petitions will be rendered obligatory in the absence of any orders. As we stated in ruling number 1, because the consolidated petitions challenge the entire impeachment process, the fundamental issues at stake remain live, even though the parliamentary proceedings have been completed. Furthermore, as previously noted, should any of these petitions succeed, this court will have no shortage of effective remedies to address the situation. The next issue is whether the applicants will be prejudiced if the orders are not granted. Regarding whether the applicants will suffer any harm if the conservatory orders are not granted, we find that no individual can suffer loss or damage when the Constitution is permitted to operate as intended. Allowing the constitutional process to unfold does not in itself result in detriment, as it upholds the rule of law and respects the framework agreed upon the people. The applicants also urge the court to grant the conservatory orders, expressing concern that the respondents have a history of disobeying court orders, and that once the office of the Deputy President is filled, it will be impossible to remove the appointee, even if the petitions were successful. However, this court takes the view that it cannot operate under the assumption that its orders will be disregarded. This country has legal mechanisms to address any acts of disobedience of court orders. Moreover, the Honorable Attorney General, through Senior Learned Counsel Professor Gachagua, has given an undertaking to comply fully with any orders which will be issued by this court in this matter. As such, we find that the applicants do not stand to suffer any prejudice in the event the conservatory orders are not granted.
Disposition. As we conclude, we reiterate that this matter holds significant public interest and we remain committed to an expeditious examination of the petitions. Therefore, we will further provide directions within this ruling. Consequently, the following orders are hereby issued. 1. The applications for conservatory orders are hereby disallowed. 2. The conservatory orders issued on 18th of October 2024 in Keregoya High Court E015/2024 are hereby discharged and or set aside. Cost of these applications shall be in course. We grant leave for appeal, type proceedings and certified copies of this ruling to be availed to parties at cost or as it may be. We will mention this matter on 7th of November 2024 at 2 p.m. in the open court. This ruling shall forthwith be uploaded in the court tracking system. That is the ruling of the court.
Mr. Blake, my lord, and you have an
Major Blake, my lord. I want to take this opportunity to thank your lordships for the time that you have taken and the judiciousness with which you have expedited the applications. And I also want to thank my colleagues from the respondent side and from the applicant side for the maturity with which this matter has been handled. We are most grateful, my lord.
Thank you.
My name is Rachel Gaude for the Deputy President, and I wish to make an application. The application I wish to make is called the Magu Paper Injunction. Magu Paper International, quite a famous case. In the common law, it's called the Ellingford Injunction. Lord, the Magu Paper Injunction operates on quite a simple premise, the premise of human fallibility. In the case of Ellingford, where that injunction originates, Justice Megari, after dismissing an application for injunction like you have now, found still there would be the slightest chance that he was wrong. Here, there could be the slightest chance that you are wrong. Last week, this court gave the Deputy President leave to appeal. We thank the court for that generosity. The Deputy President has appealed. He also has pending before the Court of Appeal an application for stay of these proceedings, and that application comes up on the 6th of November 2024. My Lord, operating on the premise of human fallibility, the foundation of the Erin Ford Omadu Pepper injunction, we request you to recognize that you could be wrong. And if you're wrong, then the pending proceedings before the Court of Appeal would be rendered nugatory. To avoid that possibility, the possibility that the Deputy President's right to appeal, which you recognized and affirmed and upheld by giving him leave to appeal even where he needed none, we ask you to issue a Madu Pepper injunction. We do not seek an indefinite injunction. We seek an injunction until 6th of November 2024, when you are next before the Court of Appeal. Thank you, my Lord.
My Lord,
we also have a moment to buy the cherry.
The Black Bull, okay.
Lords, I want to associate myself with the submissions made by my learned friend, and also state that I have listened keenly to the ruling that has been delivered by this honorable court. While we largely disagree with it and we have a right of appeal, Your Lordship, it is imperative for us to know or to assess how that office of the Deputy President will be filled. This court has affirmed its commitment to observe the rule of law and protect the Constitution as decreed under Article 3 of the Constitution. It follows, therefore, Your Lordship, my ladies, that the filling of that vacancy must flow or must follow the Constitution. And as such, Your Lordship, and as much as I have not heard the court address that very pertinent issue, it is my submission, Your Lordship, that I rise under Rule 23. Beg your pardon. Rule 23 and Rule 24 of the Muchunga Rules. And I make an application, Your Lordship, that pending the determination of this application, done